We will talk about the title of ownership, performance, and breach in Sales and Goods Act 1930 today. The general rule, as defined in Section 27(2)30, is that the owner of goods can sell the goods. Conversely, the sale of an article by a person who's not or who has not the authority of the owner gives no title to the buyer. The rule is expressed by the maxim Nemo quod non habet, which means no one can pass a better title than what he himself has. As applied to the sales of goods, the rule means that a seller of goods cannot give a better title to the buyer than he himself possesses. Thus, even bona fide buyer who buys stolen goods from a thief or from a transferee from such a thief can get no valid title of the same, since the thief has no title, nor could he give any to the transferee. So what you have is what you give, and nothing more than that. However, there are certain rules. There are certain exceptions which are there to this specific general rule. The Act, which, while recognizing the general rules that no one can give a better title than what he himself has, laid down important exceptions to it too. Under the exceptions, the buyer gets a better title of the goods than the seller himself, and these exceptions are first one is sale by a mercantile agent, sale if it is done by, let's say, a co-owner, sale by a person in possession under a voidable contract, sale by a seller in possession after sale, sale by buyer in possession, estoppel, sale by an unpaid seller, or sale by person under other laws. These are specific exceptions which are given under the general rule as far as the title of ownership is concerned. Now let's look at the performance of the contract of sale. It is the duty of the seller and the buyer that the contract is performed. The duty of the seller is to deliver the goods, and that of the buyer to accept the goods and pay for them in accordance with the contract of sale. The key word over here is deliver, which means the goods need to be delivered. And section 33 to 39 defines delivery. It says delivery is the voluntary transfer of possession from one person to another. Delivery may be actual or it may be constructive or symbolic. Actual or physical delivery takes place where the goods are handed over by the seller to the buyer or his agent authorized to take the possession of the goods. Constructive delivery takes place when the person in possession of the goods acknowledges that he holds the goods on behalf of and at the disposal of the buyer. There are certain rules of delivery which are listed over here and critical to make sure delivery happens as per those specific rules. Delivery should have the effect of putting the buyer in possession. The seller must deliver the goods according to the contract. The seller is to deliver the goods where the buyer applies for delivery. Where the goods at the time of the sale are in possession of a third person, there will be a delivery only when the person acknowledges to the buyer that he holds the goods on his behalf. The seller should tender delivery so that the buyer can take the goods. The place of delivery is usually stated in the contract. Where it is so stated, the goods must be delivered at the specified place during the working hours of a working day. The seller has to bear the cost of delivery unless the contract otherwise provides. If the goods are to be delivered at a place other than where they are, the risk of deterioration in transit will, unless otherwise agreed, be borne by the buyer. And lastly, unless otherwise agreed, the buyer is not bound to accept delivery in installments. The delivery should be in full, one go. While it is good to have it's good to have the contract go as per the deliverables defined. However, there are breaches that occur. Let's have a look at cases when the suit of breach of contract may happen, where Where the property in the goods has passed to the buyer, the seller may sue him for the price. Where the price is payable on a certain day, regardless of delivery, the seller may sue for the price if it is not paid on that day, although delivery of the goods has not passed. Where the buyer wrongfully neglects or refuses to accept the goods and pay for them, the seller may sue the buyer for damages of non acceptance. Where the seller wrongfully neglects or refuses to deliver the goods to the buyer may sue him for damages for non delivery. Where there is a breach of warranty or where the buyer elects or is compelled to treat the breach of condition as a breach of warranty, the buyer cannot reject the goods. He can set breach of warranty in extinction or diminution of the price payable by him, and if the loss suffered by him is more than the price, he may sue for the damages. And lastly, if the buyer has paid the price and the goods are not delivered, the buyer can sue the seller for the recovery of the amount paid. In appropriate cases, the buyer can also get an order from the court that the specific goods ought to be delivered. So he can force the seller to actually deliver the goods if the seller is not willing to in certain specific cases. Many a times one doesn't need to wait for a breach to happen. It can be well anticipated, and you know that the contract is not going to get fulfilled. Where either parties to the contract of sale repudiates to the contract before the date of delivery, the other party may either treat the contract as still subsisting and wait till the delivery date of delivery, or he may treat the contract as rescinded and sue for damages for the breach. So the buyer doesn't necessarily need to wait for the date of delivery. In anticipation of the breach happening, he can sue for damages in advance as well. In case of in case the contract is treated as still subsisting, it would be for the benefit of both parties, and the party who had originally repudiated will not be deprived of his right of performance on the due date in spite of his prior repudiation, and his right to set up any defense for non performance which might have actually arisen after the date of prior repudiation. So that's all we have to cover today in terms of performance as well as transfer of title. You can download this presentation from www.juristknowledge.com. Thank you.